give you all a brief introduction so that you can get to know Professor a little more, because I already had a brief conversation with him. And it's an opportunity and it's a pleasure for us to be able to host him, because he's such a learned person and he has contributed to intellectual property research also a lot. So Dr. Peter Mezei is a full-time faculty at the Szeged Law School, Hungary. He is an adjunct professor at the University of Turku, Finland. He is a visiting professor at the University Jean Moulin Leon, France, and the Bocconi University, Italy. He focuses on comparative law and comparative digital international and European copyright law. Besides teaching at various European universities, he has also delivered numerous lectures and he has joined multiple renowned conferences on a global scale. We wholeheartedly welcome you, Professor, and hope interacting with you is going to be a pleasurable experience for us again, as it was last year for sure. So the floor is open for you.
Thank you very much. And again, thank you very much for managing to managing that this event can happen and take place. 12 days before, we had to postpone the event for some technical issues and some physical issues. I practically lost my voice and I could hardly deliver the presentation on that day. So I'm very grateful for the organizers to give me another chance to present my talk here. Let me only tell you one disclaimer before I start sharing my screen, because I, of course, have a presentation which I will be very happy to offer to share with you. So I will send this PPT to Tarna after my presentation, or maybe a little bit later, because I have a meeting immediately after this session. And so I can only recommend you, as a disclaimer, not to write down everything. If you are interested in writing down my talk here, you will have the slides. Please try to focus on the focal points of my presentation and don't fear to raise questions. Last year, I had a very positive experience. I expect that you will have a chance and interest in communicating with me as well. There is a chat session, a chat forum. Feel free to raise your questions or pop in, turn on your camera, and let me know what you think on these questions. So let me start sharing. I'm disabled to share my screen. Could you please make me eligible to do that?
Yeah. Diganpai, can you please make Professor the co-host so that he can share the screen?
That would make it much easier. And by the way, another note here, before I can start sharing the screen, you will see a presentation today, which is going to give you a broad overview, introduction, and the timeline into, okay, I think something has changed because I see people in the waiting room as well. So I let them in and, and let me start. Wonderful. Sharing my screen, and from now on I give the floor back to Tarina to let people enter the room, or the organizers, and so let's start the presentation here. So as I said, this is going to be a presentation on the development of a very, very interesting question, at least for IP people, copyright people, but not only in Europe. I'm certain you are familiar with the expression of platforms. This is probably one of the most important expressions in the legal system, at least with respect to the online environment. Platforms are with us since quite a lot of time. It's a shorter period since we call them platforms, but copyright issues are constantly developing and increasing with respect to the role of platforms, role of intermediaries, as we used to call certain platforms earlier, with respect to copyright protected materials. I was very politely and fairly introduced, so I don't need to introduce myself better, but there are a few more information. And I think on my last slide, you will see my email address. Again, never fear to send me emails either, because I'm really here to answer all questions. You might be surprised, but I start my presentation with referring to a very interesting social and technological phenomenon: peer-to-peer file sharing. Peer-to-peer file sharing has appeared uh, due to two main technological developments in the 90s, 1990s. Well, guys, some of you were probably still not alive at that time. You are most probably young people. I was a teenager at the time, but I only learned about these fundamentals during my university studies. But these two technological features that have contributed to peer-to-peer file sharing were both on the one hand, internet in general. Of course, internet was standardized and published, made a way they were made accessible for everyone around the beginning of the 90s on a global level, I mean. And there was another technological invention called MP3 conversion, which made it possible for people to decrease the size of audio tracks to approximately 10% of the original size of an audio track on a CD. Why do I mention this? Napster, which was the first ever peer-to-peer file sharing stemming or originating from 1999, based its business model on the basic fact that there is a growing speed and benefit of internet, and there's a decreasing size of files capable to be sent over the internet. In 99, these two technical features met. It became not that it became possible to transfer files of 4 to 5 megabytes in a few minutes, later on seconds. That made Napster possible, and that made Napster a big hit. At the peak of Napster in 2000, it had over 100 million users. Guys, 22 years ago, internet was much less than what we have now. We didn't have Web3 as of nowadays. We have not even Web 2.0, by the way, just the linear internet, web, the first generation of the internet. Tamna, sorry, there are 27 people enter the waiting room, so you might think, okay, good, they are coming in. So in practice, in the 90s, we have seen something extraordinary, partially unexpected, but we had some other situations, bulletin boards over the internet earlier. But in any case, the massive numbers related to peer-to-peer file sharing were shocking to copyright holders. And by the way, from 99, the number of sales of audio tracks, CDs, data carriers has started to decrease. Well, it started to decrease because now it's going to go up again. But there seemed to be a big challenge and problem for copyright holders as the new millennium approached. Unsurprisingly, in the first decade of the new millennium, so 10 to 20 years before, one of the hottest research questions was peer-to-peer file sharing. Okay, this is a Hungarian book. This is a book written by me as follow-up to my PhD several years earlier. In 2012,
Professor, if I may interrupt in between, your slides are not moving. We can't see your slides moving. We are still stuck on the first slide.
Okay. Yeah. I don't know what's the situation. Okay, then I don't turn on full screen. I guess you see my
yes.
PPT. Okay. Yeah. I don't know what happens. Sorry, just one sentence. It happens to me quite often. I don't know why. Maybe I have to update Zoom. I don't know.
So that happens because when we use such platforms, maybe because of the interoperability issues that we face.
Okay. In any case, now you see. So this is the slide I wanted to show to you. Anyway, many years ago, 10 years ago, I wrote a monograph which was on peer-to-peer file sharing, and I tried to conclude what should be the solution. I'm not a genius. I just simply say I try to analyze facts and practices and businesses and law and whatever. And I found three key targets or aims or tools with which we could expect the decrease of peer-to-peer file sharing. First, increasing copyright literacy. Second, strict or stricter law enforcement. And third, probably most important, emerging effective business models. Let me sum these up in individual slides in the followings. When I speak about copyright literacy first, this is not a order of priority in some sense. Again, I mentioned I think business might be the magic solution, but I am a teacher. I do believe that in order to make fair and proper conclusions on how copyright law, legislation, right holders, courts, and society in general have to reflect on such a challenge that peer-to-peer file sharing has posed for society and everyone, we first have to understand what's that. And indeed, we first have to understand what is copyright for. Whenever I can or could do that, I spent a huge amount of time of my academic career on talking to people, teaching people, running projects. And that's what many other people did. There were many campaigns, Pro Music campaign, Why Music Matters campaign, many others. I mean, these are just examples. Sadly or not, this is the weakest option to challenge peer-to-peer file sharing for one single reason. And I tell you frankly, because that doesn't bring money to anyone. Teaching can help to a certain level, but that won't make profits for right holders, won't make re-election of politicians. People are generally reluctant to sit into persons' extra speeches other than classrooms or TEDx presentations. It's very hard to find the proper channel between education and listeners. In other words, growing the literacy of individuals seem to be a challenge, a very big challenge, but still we shouldn't give up. I will have a few more words on that later on. Next, something I try to highlight in my PhD, enforcement. Of course, you don't need to agree with me. You don't need to agree with me that enforcement must be there and everyone has to be punished. I'm not talking about punishments, by the way. We have seen that criminal law is an ineffective tool in tackling peer-to-peer file sharing. Criminal law, prosecuting 10 million Hungarians from 10 million Hungarians in this country because they do file sharing. There are not enough places in prisons. Criminal law is, by the way, not talking about financial remuneration or rewarding authors for infringements. So if there is a criminal case, someone might be sent to the prison, but the harms will not be paid, or rewarded, or the damages will not be paid. Civil law, well, in civil law, we have clearly witnessed in the last 20 years, 15 to 20 years, that countries are not necessarily up to date with liability regimes for intermediaries. In some countries, in the United States, there was indirect liability standards since as of the 1980s, contributory liability, vicarious liability. In the Anglo-Saxon countries, I guess, but I'm not an expert of Indian law, you might also know the concept of authorization, which speaks about some kind of indirect liability in British law, Australian law, as far as I understand. So maybe you have something similar. We in Europe had nothing like that. We in Europe believe in direct liability, which means very simply, the person who does the infringement, commits the crime, whatever, shall be liable for the committed whatever. It took 15 years or even more for the European Union to, especially not the legislation, but of course, to adjust to the modern needs of platform economy. I will mention a few more cases later on. I just put some expressions with Pro Music, LSG, Boni Audio, and there will be more cases that try to question whether platforms, intermediaries, shall be subject to liability or not, or what kind of liability. Again, we will get back to this question later on. And finally, PR. Guys, can you imagine a legal system that says you are liable for using internet per se? This is a very bad message that could chill the whole environment. If people would be frightened to do something, indeed, this is not the topic of my presentation today, but there is a significant amount of research on anxiety. So anxiety, yes, anxiety of students, if I pronounce this correctly, students and professors, teachers, to use materials for online and digital educational purposes because of the fear of copyright infringement. In other words, many teachers are unwilling to share YouTube links, for example, on their classes because they fear they will be sued for doing this, even if it's quite impossible, but still, you never know. People are anxious about copyright law. They fear of copyright law. They hate copyright. I don't want to use examples here, but that there are many movies from the United States where people are speaking about, oh, well, you shouldn't do this because it's against copyright. Of course, this is something that Hollywood sends to listeners or viewers. But it's a matter of fact, in the United States, if a copyright infringement leads to financial harm caused willfully, this kind of activities can fit into criminal charges, up to 5 to 10 to 15 years of prison. Wow, guys, I mean, this makes no sense. That's a very bad message for humankind. Again, sorry, there are 11 people in the waiting room, so you might let them in. Thank you. In other words, I highlighted that in my book, that I personally believe that we have to find an alternative solution, which I call bottleneck effect. There is a bottle, okay, so there is a bottle of water. Under bottleneck effect, I mean, grab the bottle at the neck. Why do I say this? Because it seems to be the tightest space. You can certainly grab the bottle here, then a big bottle on the bottom. I simply wanted to highlight here that because internet service providers, technology owners are limited in terms of number. I mean, their number is limited. You might be able to tackle them individually or massively, but there's still less than 10 million people in a country. Infringements might be managed easier if you manage the technology owners or intermediaries. I argued, again, 10 years ago that platforms must be the main targets of law enforcement. And finally, I also argued that of course, infringements are there and enforcement might help. But what makes peer-to-peer file sharing so fascinating is that it's free, it's broad, it's covered, it has a huge repertoire, it's easy to use, there's chat functionality, people form communities, people talk about things. So what should we do? We need affordable, safe, secure, DRM-free, easy, diverse, paid repertoires. Each and every of these elements are important. So if a service is expensive, no one will go there. If a service is very cheap, but they only have one movie, no one will go there, etc., etc. We need to rethink how rights holders are offering their content online. So it turned out that streaming platforms have the future. Again, I'm not genius, but I argued 10 years ago that it's quite clear that platforms like Spotify and Netflix that went online and global approximately 10 years ago will be the saviors, if at all. So this is what I said 10 years ago. And I have to admit, again, I'm not a genius. I think I fairly understood the system and I fairly properly pointed to the possible solutions and outcomes. But there are much more things that people cannot foresee or could not foresee. Again, even if I don't know, Elon Musk says what the future will be, he's just guessing. Okay, don't believe anyone who is guessing the future. Things will change in 10 years, of course, but already in 1 year. So let me sum up my experiences with respect to unexpected consequences. Okay, some of them are expected. I also expected some consequences, but some were unexpected totally. So first, I expected that streaming will dominate, and I also expected that, of course, downloading will not disappear. Peer-to-peer file sharing won't disappear, partially because Netflix wasn't present everywhere. Spotify wasn't present everywhere. For quite a lot of time, even if Spotify was present in Sweden or UK, it wasn't present in Hungary. So even within the European Union's common market, we had significant market differences, which is against the unity of the European Union's market. Of course, that's a problem. I didn't expect that the European Union will be strong enough, for example, to introduce the portability regulation. Portability regulation means you are allowed to use your lawful streaming services outside of the borders of your country. If you are traveling to Sweden for holidays, you must be eligible to use your Hungarian Spotify. Point. It's a very big thing. Earlier, rights holders limited access to platforms based on IP addresses, based on geolocation. The European Union was strong enough to introduce this. Americans never tried to solve geo-blocking. This is something we call it. On the other hand, something social, and so nothing technological here. People, many people, including me, never gave up the willingness to own, possess copies. I know I might look old-fashioned or simply old, but I love the smell of paper. I love DVDs. I love tangible data carriers. You know what? You don't need to agree with me, but I love my bookshelf shelves because I have more. I love to see what is my past in culture, what I have read, what I have done. The same with DVDs. So of course, downloading from digital and of course, tangible data carriers remain. Streaming dominates, but streaming is not the only option. With respect to downloading, possessing content, however, there is a significant problem. Something that, by the way, led to another book I published first 4 years ago. And guys, 2 days before, the second edition of my book on copyright exhaustion is out. There is the flyer of that. If by any chance you are interested in whether you are owning computer games, files, music, etc., whether you can resell these copies, if you're interested in exhaustion, get my book and read it because I think it's very useful for everyone. In any case, in this book, I argued that in the digital environment, ownership has changed. The vast majority of legal systems argue you have no ownership over intangibles, files. It's not, I'm not talking about streams because that's not a copy, at least not a permanent copy. It's a temporary thing. But in the European and American and many, I think almost globally everywhere, legal systems, copyright law argues that you don't own the files you purchase on iTunes or anywhere else. Consequently, you cannot resell them. Consequently, you are stuck in the mud. You spend money on contents, but you cannot do anything else than listening to it and then forget about that or destroy that. There are certain inconsistencies and conflicts between tangible, analog, and intangible, digital, but even in between intangibles. So streaming is cheaper and easy to use, but it doesn't guarantee you can keep the content, because if you give up the streaming subscription, you have no access to the movies anymore, point. But if you download the content, it's not a guarantee you own that either. Indeed, if you sign up for an ebook service provider, don't be surprised if the service provider removes the ebook from your machine. It has already happened several times that ebook retailers have removed ebooks from Kindle and whatever readers because they have lost the license to offer those ebooks. So the digital environment is extremely tricky with respect to ownership. Keep this in mind. And I truly believe that can have an effect on peer-to-peer file sharing again. Return of peer-to-peer file sharing is on the horizon. Why? For various reasons, including this one, because of inequalities. Next, unexpected consequence. Copyright literacy didn't grow at all. I believe there are projects, but I was very much upset to see how limited literacy projects are out there. Following my book, for example, the Hungarian government, the IP office of Hungary has decided to launch a strategy. In the strategy, they said we need to teach people. They have one training, countrywide training, but only for professionals. And the strategy was not renewed. Practically in Hungary, there is no copyright literacy project going on other than university teaching, etc., etc. Other than one thing, which I did, by the way, with a few very, very great people, some students and postgraduate students. You don't need to understand the Hungarian term either, but we made a cartoon. We called them, the band of the cartoon, we call them sheet music pirates, just for fun. We made a 5 episodes cartoon. And of course, we are not big guys. This is not Hollywood. We didn't spend any money on advertisements other than we appeared on television several times. And we had 1,000 hits. Again, this might be only a decision about quality, but I don't believe no one was interested in education. That's a poor thing, I believe. I can only recommend, if it's about copyright and modern life and society, etc., technology, we need to educate ourselves. And why do I stress this? There are plenty of blogs out there. Read the blogs. There are plenty of celebrities. By the way, forget about them. Almost anyone in the blogosphere and over the internet is willing to tell his or her opinion. Professional education is sadly limited. So I can only tell to you and to India as well, spend money, invest money into education, because that can guarantee the lawful use of contents in the future, which would certainly lead to economic increases as well. Indirectly, but can certainly lead to that. Anyway, I'm very much stressed that literacy didn't increase, but indeed it probably decreased in the last 10. Next one, data. Data is a magic word. We knew about the relevance of data since 20 years, since we have Web 2.0 applications, which are based on user input. We know that data is the next gold or much more oil of humankind, or gas of humankind. Without data, platforms would die. Without platforms, we would die. Data is now the kingmaker, as we would say. So here comes the realistic question. How does data protection, data management, data use, data protection under IP, I mean, help the platform age or help support the platform age? We have quite a lot of experience on how platforms and the data overlap with each other. It turned out throughout the last 15 years in Europe and United States, and most probably elsewhere as well, but again, I am unable to read everything. Plenty of courts have decided to order websites, platforms, through injunctions, by the way, so injunctions is the keyword here, to filter out contents, to filter out users. All of these proceedings were based on the data collected by the rights holders. In other words, in order to have nowadays a successful legal claim against internet uses, of course, you need to have the copyright, but other than that, you need to have data. So how can I get more data? How can I get data on uses? It's very dangerous business because of data protection. GDPR as well, although the GDPR is a little bit different thing. You might have learned about GDPR, or you know what GDPR is. The General Data Protection Regulation of the European Union, but it's much more about the management of data rather than the protection of the data itself. It's about how data processors or data producers have to deal with the collected or generated data. In any ways, in Europe, much less in the US, but in Europe, we protect personal data very strictly. In other words, and that's a magic thing here, it's almost impossible to freely collect data without a court order or the data owners, so the person behind the data, sorry, without the permission of the person behind the data. Voluntary data granting is okay, but unauthorized data collection of personal information is running against the law in Europe, most probably in other countries as well. Finally, liability concepts have started to mushroom in the European Union with things like liability for linking, liability for sharing contents via machines, actually, not remote controllers, sorry, set-top boxes, sorry, via set-top boxes that we use to use television in general, digital television. We have court case law on whether such kind of communications are lawful or not. And there is a growing number of liability verdicts against, for example, Pirate Bay and manufacturers of set-top boxes that allow people to access copyrighted materials. So liability mushrooms, concepts of liability develops in Europe and in the US as well. There is another dimension of law enforcement, something I must admit I was not thinking on in great details. I understood partially that certain e-commerce service providers have a role in monitoring their systems. Okay, this was easy because we had rules on that, both in the US, both in Europe, okay. But the practice of privatized law enforcement has only become a crucial tool in the last 10 years. What is privatized law enforcement? Privatization, privatizations, very interesting. Nothing else than we request platforms to filter out allegedly infringing materials. Materials that the platforms believe to run against public laws like copyright law. What does it mean? Platforms have a voice and a decision, of course, subject to contesting, so subject to appeal at courts, but they have the first voice. And of course, guys, people, maybe even you, would be reluctant to bring a case to a court if you have, for example, uploaded a video to YouTube that you would otherwise know to be probably illegal. But there are many people who simply cannot afford that. There is a real challenge with respect to false positives. That's what I mentioned here. There's a real chance that people's expressions are filtered out because of the inequality of weapons. Platforms are strong, they have IT stuff, they have the time and money and incentives to filter out contents, because in the lack of filtering, they might be subject to liability. We are approaching a world, well, currently we are there, but in the last 10 years, we have approached a world where platforms turned out to be the leading law enforcement actors. Not to mention such cases like the Cox decision from the United States from 2018, final decision, I mean, which argued that internet service providers must be found liable except if they have a functioning repeat infringer policy and they kick out from their internet system repeat infringers. In the Cox decision, by the way, Cox was a blatant infringer of the provisions. They never terminated any user accounts, even if they have warned users 14 times of infringing activities. And I only mentioned 14 times, but I don't want to get into details here. But one warning was sent out, hypothetically, and it happened, on a daily collection of notices. Cox has collected notices from right holders with respect to end users up to 200 per day as a maximum. In other words, if a person was a massive infringer and rights holders sent 10 warnings or 200 warnings to Cox on a single user, that would only lead to one warning. So you can mathematically multiply 14 with 200 as well. Maybe infringers, users have done close to 3,000 infringements before they were not even terminated. The US courts are keen on forcing the bottleneck holders, the technology owners, to kick out massive and repeating infringers. But for example, in Europe, we have no policy like that. I'm not sure whether India has that or not. Maybe not, but very interesting. There are growing technological solutions, but growing focus on the technology owners in law enforcement. I haven't foreseen that, I must add. Next thing, sorry, 5. Something which is probably the most crucial thing here. It's all about the money. It's the whole business of platforms is about money. It's not about moral rights in copyright. It's not about cultural development, cultural preservation. By the way, peer-to-peer file sharing has done much more for cultural preservation than Netflix does, actually. But I'm not soliciting here for peer-to-peer file sharing. I just simply say that streaming is about licenses, is about market shares, it's about control and many, many magic words. Indeed, look at my screen. Again, you will have the slides and you will be able to look at the pictures much easier, okay? But here I try to highlight wonderful information. As of now, I mean, around the end of the third quarter of, or second quarter of the last year, Netflix, Amazon, and Disney had a massive, over 100 million users share on a global level. Netflix had 222 million at the end of last year or something like that. And there are many, many smaller service providers, by the way. In any case, we are far from certain that the current growing streaming wars will be the savior of copyright and entertainment. Why do I say this? There is certainly a maximum number of users. Indeed, with options like Netflix's code sharing, so you can share your subscription with many people. The same for Spotify, blah, 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 depending upon the version you have or subscription version you have. In any case, there is a ceiling for available users, subscribers. In other words, there are maximum income possibilities for platforms. But since platforms are running much more like as corporations, streaming service providers, as corporations, who have shares, who are on the stock exchange, if the numbers of the numbers are not increasing enough, their shares can decrease. The value of their shares can decrease quite easily. It sounds like paradoxical that Netflix is adding millions and millions and millions of people every quarter, but the number of millions is decreasing, and therefore the value of Netflix is decreasing. Very interesting thing to understand how economics operate. Plus, Disney Plus. Disney Plus is the best example to highlight the looming, harsh streaming wars. Why? When Disney Plus appeared on the streaming ecosystem or in the streaming ecosystem, they purposefully decided to withdraw their licenses granted to Netflix and other platforms. Why? Because they want to be the exclusive hosts of their own contents. Disney, Pixar, Marvel, blah, blah, Star Wars, blah, blah, blah. Okay. What it means that if you are a Star Wars fan, you must have Disney Plus, otherwise you won't see Star Wars stuff. Netflix has the same issue with other producers. And all the big producers are either running their own platforms or teaming up with other services to run a platform. Peacock, for example, Apple TV, Paramount Plus. These are offering exclusive contents. But what's the consequence? If you want to have a broad repertoire, to enjoy a broad repertoire, you might need to sign up for multiple services. I only learned from the news that Netflix is offering its service in India much cheaper than in other countries. Guys, don't misunderstand me. It's not because you are, it's not because anyone is poor, but they understood they cannot compete on a big market. By the way, probably a little bit more expensive than necessary, where people have other priorities as well. That's the same for Eastern Europe, by the way. Eastern Europe has its own issues. We think Netflix is overpriced. We, by the way, pay around 12 to 15 euros per month. I think you pay a few dollars, or I don't actually know how much is Netflix at the moment, but certainly less than in Eastern Europe. For a Western European or American, this is nothing. American households spend approximately $200 on streaming per month. $200, come on. I wouldn't spend that much amount of money, certainly. But this also leads to unexpected, this is something I never expected, consequence. Movie theaters are going to die because of streaming. By the way, partially because of COVID as well. But people started to skip movie theaters, going to movie theaters. It's not necessarily true in the sense that, of course, many people love movies. But there's another big challenge. You probably heard the news. Some producers decided to put the movies into theaters and on streaming the very same day. This might be an ugly thing with respect to movie theaters per se. Movie theaters won't have everyone for a period. Although for decades, that was the thing. Movies, data carriers, television, pay television, blah, blah, blah. So first pay television, then public television. In any case, this is not the only problem. You would believe or not, there is a different license fee for movie theaters and streaming. If movies are put on streaming the same time as movies, the higher fees or license fees or royalties that movies can generate will decrease. Streaming is cheaper because it must be cheaper to increase the number of users. I stop here with this, but I could speak too much. But there's a spiral. There's a spiral of newcomers need to decrease the price, need to increase the content, language varieties, blah, blah, blah. I am not certain this will lead to a good thing. I personally believe both that streaming is fun and that it's a bubble. I believe there is a great danger that the streaming bubble will explode. And Peacock may be first Peacock because it's going to be poorer and poorer. But who knows? They might disappear. Or mergers will come. And if mergers come, there will be serious problems with respect to access due to competition concerns. Anyway, so we have to keep our eyes on the financial aspects of streaming as well. Finally, copyright law is in flux. So it's not only about business and technology which changes, but copyright law reflects on these, and copyright law therefore also changes. Courts make decisions, legislations make political decisions as well. They want to have re-elections, so they want to have solutions for problems that their voters, including rich corporations, need an answer to. So copyright changes. Plenty of questions were present with respect to liability. I have mentioned some of these. Safe harbors for intermediaries. Shall we give an exception for Google and eBay and Facebook and whatever the same way as we did it 15 years ago? Life has changed a lot. Shall we revise our copyright and e-commerce and connected rules? Shall we change law enforcement? And the answer seemed to be and turned out to be a great yes, both in Europe, US, and there was, a small T. Before I once again lose my voice. So I'm focusing on the European Union now and platforms. There were quite a lot of court decisions, early court decisions and later court decisions with respect to platform liability. Earlier, originally, trademark decisions came with respect to marketplaces offering counterfeit trademark goods. eBay offering bad stuff, Google search engine offering the chance to look for counterfeit products. Later on, we started to have copyright decisions, Sabam, Zigo case, and a very important one, the YouTube Siando quite recently. We have witnessed an organic development in introducing the liability of platforms if they are active contributors, active supporters of infringing activities. Unlike in the United States, however, that active role was turned out to be or treated to be direct liability. In the United States, liability of intermediaries has always been indirect, which required the evidence for a direct liability of someone, a user. Now in Europe, we have a direct liability concept for active intermediaries. Intermediaries active with respect to the acts of end users. Jump. And there came something very interesting. Many years before, music rights holders, especially sound recording producers, have introduced a brand new argumentation, the so-called value gap. They said that platforms like YouTube and others who don't pay for showing contents to end users are generating a huge amount of income, but pay a very low amount of royalties to right holders. Those streaming service providers like Spotify generate a lot of money based on a much smaller number of users, but pay royalties as well at a much higher rate. Rights holders argued that free internet music shall not be okay anymore. We must regulate those platforms who offer free internet, uploaded by their users. That has ultimately led to a very important European Union legislation, the so-called Copyright in the Digital Single Market Directive, accepted in 2019 to be introduced last year. Not every country of the EU has done that yet. So more than a half year after the implementation deadline. We still have countries with no amendments yet. I am focusing on two aspects of this Article 17, as we call it. First, filtering. The new provisions oblige online content sharing service providers, whatever stupid word this is, or expression this is, some platforms, those platforms which offer end users to share content on their platforms like Facebook and YouTube. The system obliges them to filter out illegal contents, otherwise they will be directly liable for those contents. So the new brave or wonderful word is that platforms must play an active role in kicking out illegal materials from the internet. Of course, questions come, wouldn't it be counterproductive? Would that lead to chilling effects on freedom of expression, or simply over-filtering of contents and parodies will be also filtered out? Will there be too many false positives? Will people be able to complain about too broad filterings? We have no answers on these questions yet. Europe's current hottest question for platforms is whether they will do it properly or excessively. Second, directly, fundamental rights. Is the new system capable to balance freedom of expression, freedom to run a business, freedom to depart and receive information, freedom to teach, freedom of education, freedom of expression in a way like parodies? We still don't know. What we know is that there is a Court of Justice proceeding in the European Union where we already have an Advocate General opinion, which is an argument on how to decide a case by the court. And the Advocate General from Denmark has said the new rules are intrusions to fundamental rights, but not unconstitutional, because they are proportional and necessary intrusions into end users and businesses' interests. I truly believe this will be the outcome at the court as well. So we will keep Article 17. In other words, European copyright scholars and also Indians, because you have to keep your eyes on the world to see how you can develop your own system. You have to check how YouTube, Facebook reacts on this. A quick note, by the way, Facebook or Meta has already said, although not for copyright, but data protection issues, has already said they might leave Europe. There will be a chance for decreasing number of services due to copyright or whatever data-related complaints. Very shortly before I finish, I also did some empirical research with the help of my colleagues in Hungary and in the Netherlands on the legislation of selected countries with respect to platforms preceding Article 17. Only a few words about these, some information. If you need, I can give you the link very soon to our final report on this question as well. What we have found is that almost all countries know what these kind of intermediaries are, like Google and Facebook. They have legal provisions for them, but 80% of the countries had no direct liability for them so far. In fact, the European Union really seems to reach a proper and new harmonization of law, because a majority of the European Union member states have to introduce a brand new concept. Of course, that might have its own problems, as I already highlighted. Next, there is certainly injunctions with respect to internet intermediaries. 90% of the countries reported that. But what's much more interesting, that there is no functioning content moderation system in the vast majority of countries yet, or sorry, at the time when we made the research. It really seems so that countries had an extremely diverse system, which was based either on purely statutory provisions, how to filter contents, based on statutes and cases, only cases, duty of care, self-regulation, and some countries had nothing. The European member states have to introduce an almost unknown solution for illegal contents over platforms. Again, what it means, it's a harmonization, but with serious problems, challenges, or possibilities that there will be problems in the future. And finally, one thing I want to highlight, 100% of the countries confirmed there is a direct liability for end users to upload illegal contents to platforms. And 0 country reported case law on that. In fact, no countries really had any cases against you or me, end users. Now, the new system will make it easier because the liability will be on the shoulders of the platforms rather than end users. But never forget, I said, privatized law enforcement. You will certainly have negative consequences if you are doing illegal activity. Before, you were not sued. Now you will be kicked from YouTube. Now you will be kicked from Facebook. You lose your account. That seems to be a harsher law enforcement for the vast majority of users, at least in Europe. I could speak so much. I could speak about this question much more, but because 1 hour passed by, and maybe, hopefully, you will have some interest in raising questions. I stop here. I see there is something in the chat. Oh, sorry. You can direct your questions in the chat. Guys, don't fear. Don't fear to raise questions, because this is why we are here, to understand both each other and understand the problem at stake.
Thank you, Professor, for such an interesting session. And it was indeed pleasure listening to you and getting to know so much about all of the intermediary liabilities. Now, because you spoke about the intermediary liabilities and all of that, in India, we basically regulated through the Information Technology Act. And here we provide under Section 79 of the IT Act a safe harbor clause to the intermediaries. So plus, apart from providing the safe harbor is provided only when the intermediary does not have any knowledge about the content and the data which is being shared. Otherwise, the intermediary is directly liable for it. So it's a primary liability which is being fixed over there. So as you were giving us examples for US, that a direct liability is being fixed over there. So same is the kind of the scenario which we basically follow in India too.
Okay.
Yeah.
Indeed, I mean, just a quick note. And of course, can you really believe that they don't know about illegal stuff? That's the real question here.
Yeah, that's again knowledge? A question of empirical research, of course.
Absolutely. True. Very interesting question. What is knowledge? Yeah. Whether it's active or passive? Should it be a notification based, etc., etc.? Very interesting question.
And it becomes very difficult to trace when it comes to the technological interface with all of these aspects, because you have so much in the black box of the technology that you can't really trace the original source of it. So that also brings a lot of interesting questions for us. So we have, because of the paucity of time, we'll just take up 2 questions from the chat box. The first question is related to what about the fair use, or basically the fair dealing exception that we have in the copyright legislation? Can these defenses also be used when we talk about the end user P2P sharing or
oh, you are talking about peer-to-peer sharing. Okay.
Yeah.
Let me reflect, by the way, in 2 dimensions, two tracks, because fair dealing, as your country knows, something like fair use, etc. We would rather call them limitations and exceptions in Europe. Very good question. I could probably spend an hour here with introducing how this looks like in the jurisdictions I know. The general answer is that there is case law from the European Union and the United States, both, which confirm that peer-to-peer file sharing runs against fair use, fair dealing, or, for example, private copying, or other limitations and exceptions. In the United States, fair use requires that there is no financial harm, there is no replacement of the content on the market, there is no full copying, etc. Fair dealing is a little bit different, but fair dealing is also different in the sense that it's not an open concept, it's a closed concept. A full list of options are present, and if it's not fitting into that concept, then it's not a fair dealing. There might be a fair dealing for parody in countries, but peer-to-peer file sharing is rarely done for that. Maybe for education, but peer-to-peer file sharing is rarely done for education. Private copying is quite a fresh concept of fair dealing in the UK. I'm not an expert of India, maybe in your country as well. It's really not the proper excuse, I would say. But the first idea that came to my mind with respect to fair dealing was not peer-to-peer, but platforms and the Article 17 issue. Very importantly, the new European system has stressed that filtering shall not affect end users' fundamental freedoms or user rights like parody, citation, or other lawful limitations and exceptions. In other words, while it seems to be that we still fight against peer-to-peer file sharing also with the help of no fair dealing arguments, fair dealing must be acceptable, limitations and exceptions acceptable in the platform environment. That again makes the platform environment more acceptable, in my humble opinion. But very good question. Thank you very much. And by the way, I didn't see the question.
Actually, they have been directed to me.
Ah,
yes, okay. So I'll just read out for the purpose of smooth flow of the session. Yeah. Another question is, how will the bottleneck enforcement system work in today's world of artificial intelligence? As technology is so fast that by the time enforcement takes place, it may lose its purpose.
Okay.
So it's kind of an opinion-based question, I guess.
Well, but I can also say an opinion rather than a real answer, because this is a very good question, by the way. Very hard to answer in the sense that I am not absolutely certain that 2 points of the question are correlated. So the mere fact we have more AI does nothing that much to do with enforcement per se. Or in other words, the mere fact that people might use AI to generate this or that is not necessarily an enforcement issue. Maybe they do lawful stuff as well. But I want to respond as well. AI can also be used for enforcement, and platforms do that. Many platforms, YouTube, Facebook, everyone else, at least those who can afford artificial intelligence, they filter out contents with algorithmic solutions. Enforcement is also algorithmic. Privatized enforcement, which I mentioned, is not slow, extremely quick. Indeed, it's occasionally ex ante, which means preceding the upload or preceding the use, rather than ex post, following the upload of the content. YouTube's MD5 filter, content ID system, checks the content before it posts publicly in a few seconds, or even quicker, and done. I like the question. We should keep our eyes on AI, but I think this issue has to be discussed in greater details. I'm not sure the question was absolutely correct, and my answer is absolutely relevant for your question, but it's certainly an issue to keep in mind that AI is out there on every level: users, rights holders, platforms, countries, so states, governments, Ministry of War, etc., etc. So AI is everywhere.
Indeed, but we also need to keep in mind that as of now, human intervention is not completely outruled in all of these platforms. though technology is facilitating the content uploading, but yes, the human filtration is still in place. So maybe that is the reason this debate would be much more relevant post 10 years, probably, when AI completely replaces the humans in these fields. So with this, I would like to extend a warm thank you to you, Professor, for sparing time for us. And apologies for not being able to host you on the day scheduled, but you still spared time for us and you requested for a reschedule and you did accept our request as well. So thank you so much, and hope to host you again next year and have a very great discussion on another contemporary topic next year as well. Okay. Thank you so much.
Same to you guys. Have a nice one.
Thank you.
Bye-bye.